The time is 8:10, and the subcommittee on asset forfeiture will come to order. The clerk will call the roll.
Chair Harrison.
Here.
Representative Christina Morales. Here. Representative Schatzline.
Here.
All right, a quorum is present. A couple of quick notes before we begin. Members, I wanted to start by saying that I'm grateful to Chairman Moody for establishing this subcommittee. Asset forfeiture is one of the policy areas under the umbrella of the Criminal Jurisprudence Committee, where I believe members on both sides of the aisle can come together and find common ground and create real solutions for Texans. We're going to be making decisions here and considering consequential policy areas that have the potential to affect the lives of millions of Texans. And I believe that certain aspects of asset forfeiture in Texas deserve serious and thorough attention of the Texas legislature. So I again want to thank Chairman Moody for giving me, especially as a relative newcomer to the Texas legislature, the opportunity to chair this committee, and thank all of you in advance for the time and effort you will undoubtedly invest into these issues as well. All right, let's get moving. A quick reminder, anybody who's present wishing to testify before the committee, please register at the kiosks located in the hallways behind the hearing rooms. If you require assistance in registering or testifying, just please contact the committee staff. Yeah, that's right here. Oh, we can do this one today. Yeah. Okay, and to accommodate everybody who's wishing to testify today, we are going to have a time limit of 3 minutes per witness during the public testimony period. And we'll go ahead and jump right in. The chair lays out HB 928 and recognizes Representative Dutton to explain the bill.
Good morning, Mr. Chairman and members. Thank you for hearing this bill. You know, generally, government is the only entity that's legally, generally, that can take your life, your liberty, and your property. Government is the only. And in most cases, what we do is we have protections in the law when the government decides to do that. Except they don't exist in this case in terms of civil asset forfeiture. Because what the government can do is can come and seize your property and make allegations that they were the fruits of some criminal exercise or episode that you were engaged in, but they don't have to prove that. They don't have to prove that it was really coming from the results of a criminal episode. I've represented many people in these cases. The last gentleman I represented, he was gonna, he had a lawyer that he was trying to pay, and the lawyer would only take cash. And so what he did is he went and took the money out of an account. He was going across the street from his house, and the police came down the street and asked him why he was jaywalking. And he said, look, they had a conversation that didn't go too well, and the police arrested him, and he had $9,000 in his pocket. And the police confiscated the $9,000. There was no criminal prosecution in his case. It was alleged that he had been engaged in a criminal activity, but that never happened. He never had a chance to prove that it didn't. Coincidentally, since I had been down this road before, what typically happens is the DA, in this case in Harris County, they had two DAs who were handling these cases. And what they generally do is they would send the person, they actually file suit against the money. They don't file suit against the person. It's the suit against the money. And when that happens, what they do is they will send the lawsuit to the person who is alleged to have owned the money. They also sent what's called requests for admissions and all kinds of discovery. Now, the requests for admissions are tricky because if you don't respond to them in 30 days, they're deemed admitted. And so what happens is you lose the right to get the money back because you didn't respond. Now, this happens more and more, except in my case, we were able to respond to it. But even when we showed up to court, the judge said, well, Mr. Dutton, why are you here? I said, well, because they took this man's money and we want it back. And the DA said, well, he didn't respond to the request for admissions. And the judge said, yes, he did. It's right here. Because typically that doesn't happen. And so you lose. That amounts to about, I think at last count, we had some $50 or $60 million that was taken in Harris County. So I will leave you with it. What this bill does is says simply that there will have to be a criminal conviction before the government can take your property. And that's all it does. There are other problems with civil asset forfeiture. There's a court ruling that indicated, for example, that the exclusionary rule didn't apply to civil asset forfeiture. Now, think about that for a minute. That means that even if the police were deemed to have done something that results in them violating your constitutional rights, the proceeds of that still can be taken by the government. I may come back later with something that says the exclusionary rule does apply to civil asset forfeiture. With that, Mr. Chairman and members, I'll just stop and answer any questions you have. I'm sure there are people that testify here against this because this is the 8th time I've had this bill. And so I know who the characters are that are going to show up, and I even know what they're going to say. And they're going to come up and tell you that, well, this is, but listen to them, and I think at the end, I think what you have to do is stand on the side of the people of Texas. And with that, I'll close, Mr. Chairman, and ask if there are any questions.
Thank you, Representative Dutton. Members, any questions for? Okay. If there are no questions, we can go ahead and proceed to testimony then. And the chair calls Rebecca McIntyre. You bet. And you mind just stating your name, who you are testifying on behalf of, and if you are speaking on, for, or against the bill.
Thank you. Chairman Harrison and members of the committee, I am Rebecca McIntyre. I'm an assistant district attorney in Tarrant County, and I am here on behalf of the elected district attorney, Phil Sorrells, speaking against this bill. I have 29 years of felony prosecutorial experience, which includes, going back to the 90s, about 5 years of asset forfeiture work then, followed by approximately 20 years of criminal forfeiture or criminal prosecution. And now I've been back in asset forfeiture as the chief of the asset forfeiture division in Tarrant County for about 5 years. I feel I bring a unique perspective in that I've worked in both criminal law and asset forfeiture law extensively. And what I've seen is that most crimes are profit motivated. Having that at its core, most criminals realize that they can and will go to prison if caught and convicted. However, if the benefit to be achieved, a monetary benefit to be achieved is enough, then they'll accept that risk. They'll take it and they'll run with it. Civil asset forfeiture is a way to deter criminals from the actions by taking away the ill-gotten gains. We wouldn't say that a bank robber, if he got the bank's funds back to his house and bought a car with them or hid them under his bed, got to keep those ill-gotten gains. It's the same thing when we look at drug dealing or any other crime that creates a profit, whether it be human trafficking or trafficking in fentanyl. It's the same thing. It's done for profit. We don't let a criminal keep the profit of his crime. Now, the law requires a showing of probable cause that the property in asset forfeiture is contraband. It is a civil proceeding. However, in order to get to the forfeiture part of it, we have to prove that the property we've seized is contraband, which requires a showing of an underlying listed offense from Chapter 59. If we don't prove up that underlying listed offense, then we can't prove that we have contraband that is subject to forfeiture even. That has to be proven. The same rules that apply to civil forfeiture and the same burden of proof, preponderance of the evidence, is applied to all civil cases for any amount of money. And it has been throughout history. There are protections for respondents in civil asset forfeiture cases. They are entitled to be represented by an attorney if they choose, or to represent themselves pro se if they choose, like they are in many criminal cases. That's not different. And when it's a pro se respondent, they are given great latitude by both the courts and by the prosecutors, because we understand that they are not going to come to court as a litigator. They're coming to court as a citizen. And it often plays to their favor, quite frankly. I would suggest that requiring a final conviction for forfeiture is a bad idea. It's bad public policy. There's many reasons that we would not have a final criminal conviction, including no one found in possession of the property at the time it was seized, persons who are paid to transport, say, a car or other contraband without knowing that there's fentanyl packed in every compartment of it. We would seize the vehicle, but we would not be prosecuting that person unless we could prove guilty knowledge of the act they're committing. Confidential informants who work off cases, their cases are not criminally charged, but in fact, there could be a forfeiture. And if I may, Chairman, also deferred prosecution programs and drug
We gotta be
treatment
pretty quick,
courts.
though. Yeah.
May I-
I'm just saying we do got to be pretty quick here. We're on the red.
Yes. Drug treatment courts and deferred prosecution programs are good reasons where people admit guilt of an offense, but then are not convicted. And that's something we want to encourage by public policy. Thank you.
Thank you very much for your testimony. Quick question. You mentioned
sir.
in your hypothetical situation a statement that I doubt anybody would find disagreeable, that we shouldn't let criminals keep their ill-gotten gains. Is it your position that Representative Dutton's bill would be inconsistent with that principle?
Yes, it will be in a lot of ways. I mean, when you have a CI or someone who is going into a deferred prosecution program, they're admitting their crime. They're admitting they did it. And there would be no criminal conviction.
What about in instances where there's not an admission of guilt?
Well, we would still have to prove our case. And that's, I mean, if there's not an admission of guilt, we have to go in and prove it. It's not just going into court and your property is taken. We have to present proper evidence. And every respondent has the opportunity to present contradictory evidence or any other information they want the court to consider. And they frequently do, and they do a very good job of it, quite frankly, because it's in their possession to present how they achieved the funds or where the property came from, if it's an inheritance or anything else. People can prove those things.
Thank you very much. Members, questions?
Thank
Representative Schatzline.
Thank you, Chairman. Real quick question for you. Oh, no worries. So could you give us an example of maybe some ways that civil asset forfeiture has helped in the proving of a case or, using, whatever was seized as part of evidence? Is that common? Is that something that takes place?
It could very well take, I guess the first thing I think of is if you have a car registered in someone's name. We do have people that come in that do not want to claim their property because it puts them too close in proximity to the drugs or the other criminal offense. You can't actually claim the property without asserting that you have committed the crime. It's too closely tied. So sometimes they let it go for those reasons. But certainly if we find drugs in a car and it's titled in their name, or we have undercover officers that have conducted surveillance and seen them driving the car to and from a stash location where they're dealing drugs out of a house or another location, then that actual vehicle that would be seized is an instrument of the crime and would tie them to the crime.
Thank you.
Any other questions, members? All right, thank you very much. All right, the chair calls Devin Polk. And thank you for being with us. If you don't mind stating your name, who you are testifying on behalf of, and if you are speaking on, for, or against the bill.
Good morning, Chairman Harrison, members of the committee. My name is Devin Polk, and I'm here today representing Dallas Police Department and the Texas Police Chiefs Association to testify in opposition to House Bill 928. I currently serve as the major of the Special Investigations Division with the Dallas Police Department, which includes our narcotics and vice units. I have served with Dallas Police Department for 16 years and have additionally commanded DPD's gang unit as well as fugitive unit. I have extensive experience investigating and commanding units that target organized criminal activity to include drug trafficking, human trafficking, and gang crime. Asset forfeiture is a powerful tool utilized by Texas law enforcement to combat organized criminal activity by depriving criminal organizations and individuals of the proceeds of their criminal activity, as well as property that is utilized to further their criminal activity. Law enforcement utilizes asset forfeiture to disrupt, dismantle, and deter those individuals who commit illegal activity for financial gain. An example would be the forfeiture of assets that are the proceeds or contraband of trafficking fentanyl within the state of Texas. Drug trafficking organizations within the state are amassing significant financial assets through the trafficking of fentanyl. These assets are reinvested into drug trafficking organizations to further their trafficking efforts, as well as to drive the violent crime necessary in order to protect their criminal enterprises. The passage of House Bill 928 will require a final conviction for an underlying offense for a forfeiture to occur. This action will increase caseloads of civil dockets across the state, as criminal cases must reach finality prior to a civil asset forfeiture proceeding advancing. This problem is exacerbated by criminal dockets throughout the state that are already significantly overloaded due to the pandemic. Additionally, individuals whom accept an offer of deferred adjudication for an underlying offense often make a judicial confession to their criminal conduct. If that individual has their case dismissed due to completion of probation, that individual will have assets returned to them, assets that were involved in that underlying criminal activity to which they have admitted their guilt. For the previously stated reasons, we stand opposed to House Bill 928. Please allow me to give my thanks to the Texas Legislature for y'all's continued support of Texas law enforcement. Thank you for your time, and I'm pleased to answer any questions that you may have.
Thank you very much for being here, and also thank you very much for your service.
Thank you.
Members, any questions for the witness? Thank you very much.
Thank you, Chair.
All right, Chair would now like to call James Smith. And again, if you don't mind stating your name, who you're with, and if you're on for or against the bill.
No, thank you. Thank you, Mr. Chairman, and rest of the committee members. My name is James Smith. I'm representing the San Antonio Police Department, and we oppose the bill. I guess I would be one of those cast of characters that has testified over the years in opposition to this bill. I feel I'm an esteemed company. I'm going to take a little different approach about what asset forfeiture does. I've been serving as the asset forfeiture sergeant for nearly 15 years at the San Antonio Police Department. Everybody wants to speak about the drug charges. Let's talk about a lot of the criminal instruments that are seized to further people's operations. Let's talk about the DWI force. This was great legislation that was passed probably about 3 or 4 sessions ago, where if you have 3 prior convictions, we're going to seize your car on the fourth thing. If we have to wait for that final conviction, imagine giving that car back until we get that final conviction. Those people are not going to stop drinking and driving. They're going to go out and put everybody at harm in this room. Let's talk about those individuals who are using cars to break into our houses, our constituent houses, okay? And everything always ends up coming back. They're breaking into these houses, they're breaking into people's cars because it's all about sustaining their drug habits. It always ends up coming back to that. But do we not want to help the average citizen out there who's being affected by the drug trade? It's not that they're getting drugs sold in front of their house. It's that their house, their properties being stolen, their cars are being burglarized. Let's talk about the human trafficking of what's going on right now. Today, of all days, it has only gotten worse in my time having served in this capacity. I'm going to tell you, Chapter 59 has been vetted. It's been vetted over the years. And if there are issues out there, they've been dealt with. I've always been told, we will be part of the solution. If there's a problem, let us be part of the solution. But we don't hear about these problems. There's one-offs here and there. That's always going to happen. But I'm going to tell you, I'm speaking for myself. I can't necessarily speak for everybody else in this room, but I'm going out on a very large limb. And I can tell you, people are doing things right when it comes to forfeiture laws here in the state of Texas. And we're protecting private property rights. I can tell you operationally how we do it. Somebody comes in, they say the car got seized. It's grandma's car. We bring grandma in, let her know. She gets that car back that same day. Now she is put on notice. If Johnny's arrested in that car again, we're going to file seizure cases on it. But we cannot file any seizure cases unless we have a nexus, a direct link to one of the criminal charges or enumerated offenses that we have in Chapter 59. We can't do it. If our evidence goes bad, if the evidence is bad on the criminal side, we can't use it in our case, and we're going to have to drop our case. I am constantly
You're at time, officer. Sorry.
Oh, I'm
If
sorry.
you just wrap it up very quickly.
No, and like I said, this is a great law. It's been vetted. These changes aren't needed, and I'll answer any questions you might have.
Just to be clear, you said it's a great law. You're testifying in opposition to this.
I'm talking Chapter 59 as it stands.
Thank you very much, and thank you for your service, officer. Any questions, members? Thank you very much. All right, at this time, the chair would like to call Elizabeth Miller.
Thank you. I wanted to thank the committee for.
Real quick, if you don't mind, just
sorry.
stating your name, who you're testifying on behalf of, and if you're on for or against the bill, please.
My name is Elizabeth Miller. I am for the bill, and I'm testifying on my own behalf.
Thank you.
I happen to be a resident of Tarrant County, so I needed to speak up today and say that I personally find asset forfeiture a abhorrent practice. We have a concept in this country, legally innocent until proven guilty, and I have yet to hear speakers when they've come up on this to address the constitutional issues. But as a member, as a resident of Tarrant County, I had to come say that it's unfortunate to see Tarrant County using resources to come down here and defend this practice as a resident, as somebody who could be victimized by this. And I just got to say, it's the representative for Tarrant County for that Senate district for the Libertarian Party, I got to say, I don't need to do a poll to know what they think. This practice is universally abhorred, and we would like you to reform it. And it's frightening, frankly, to be here saying, I wish Tarrant County weren't using resources to defend this abusive practice, because now I'm vulnerable. Right? Law enforcement could pull me over and take my stuff, and that would be unfortunate. So I just wanted to speak on behalf of Tarrant County residents. Thanks.
Thank you very much for being here. Quick question. What, in your opinion, and I think you maybe have alluded to this, is the impact as operationalized and executed of current law regarding civil asset forfeiture on the principle of presumption of innocence until proven guilty?
Well, things are taken from a legally innocent person. They haven't had their due process to prove that they are guilty of the crime for which they're accused. And frankly, Tarrant County law enforcement just admitted in response to your question that they use that opportunity to get the evidence, and then sometimes that's helpful in proving other crimes. So that's getting around other aspects of the Bill of Rights where we say, no, you have to have a reason to suspect to come look. They get the reason to suspect by taking stuff from legally innocent people. So it's easy to see how people, and for some of us, losing that property is immensely impactful.
Thank you very much. Members, any other questions? Thank you for being here. All right, the chair would like to call Derek Cohen. And per usual, if you would mind stating your name, who you are testifying on behalf of, and if you are speaking on, for, or against the bill.
Absolutely. Thank you, Mr. Chairman. I am Derek Cohen. I am about to be the least popular person in the room, testifying in support of HB 928. I'm the Vice President of Policy at the Texas Public Policy Foundation.
Thank you.
So, while no reasonable person denies that criminals should be denied the fruits of their ill labor, nobody's suggesting that should also suspend due process as well. We're in a situation where the mere allegation of criminal activity is enough to start one of these costly forfeiture proceedings that often takes months, if not years now, with the backup that we have, but also incurs a lot of costs that are not covered by any indigent defense or indigent counsel for the accused. And of course, I do need to point out that when we talk about accused, the actual property is that which is accused. It's an in rem proceeding wherein I say this car is guilty of drug dealing or whatever the case might be. Now, there's going to be some testimony, and I think a lot of people get sucked into the weeds on what civil asset forfeiture proceeds are spent on. And while I'm saying that that is not a thing that we should let off scot-free, we have one agency that has testified in the past that spent nearly $700,000 on laptop bags. We shouldn't let that go. That doesn't actually deal with the process that it goes through themselves. So how much forfeiture is actually happening in Texas? Well, as of 2021, we had 34 million that went through the various entities that are allowed to actually do that. Now, How much of that was pursuant to what is tantamount to criminal activity? How much of that was simply through the civil side? I can't tell you if it's 90%. I can't tell you if it's 9%, simply because we don't have the mechanisms in place wherein that data is actually gathered. We basically have a note from the Attorney General in aggregate what it is every year, and you would need to file an open records request in order to get any sort of granular information, which is still aggregated by agency. And so some of the things you've heard is that you can't forfeit property without a criminal charge. Obviously, there only needs to be the mere allegation of a criminal nexus to get that proceeding underway. And that's only proven, not proven in any way that anyone trafficked in in the criminal canon would recognize, beyond even beyond a reasonable doubt. But we're only talking here about preponderance of the evidence. Basically, this also conflates a little bit with the process of seizure. Remember, seizure is when law enforcement actually takes possession of an item, and not to relinquish it because it's per se contraband and will remain such even under this particular bill, and not relinquish it just because the criminal trial is not moving expeditiously. And then finally, you also hear that forfeiture has all these due process protections. It has a lot of procedure. It does not have a lot of due process, and I think Bennis v. Michigan was rather clear on that, even though it upheld it. Finally, in closing, I'd like to say that this is good bipartisan legislation. Both the Republican platform and the Democrat platform both explicitly call for the abolition of the practice. Republican platform more strongly so, saying we call upon the legislature to abolish civil forfeiture independently or in partnership with federal authorities and to ensure property rights are only forfeited upon conviction.
Thank you very much. Quick question, and I appreciated you attempting to quantify a little bit the scope of the issue for us. I was going to ask you about that. You detailed several, maybe I will characterize your description as inadequacies in the data or a lack of granularity. Is there any way to have any idea of roughly what percentage of the 34 million, I think you said 34 million in forfeiture, was subsequent to a criminal conviction?
No, there is no way to do that. The way Chapter 59 is currently structured is that every agency that is subject to or that is able to engage in forfeiture must report yearly to the Attorney General's office, and there's a form for doing that both on their website, and those are again open to Freedom of Information Act requests. But even that, it's in total aggregate of the agency. So things that'll be slam dunk civil forfeitures pursuant to a criminal conviction, and ones of the highly dubious nature get poured into the same bucket.
Okay. Thank you very much. Members, any questions?
Thank you.
Thank you very much.
Anytime.
All right, Chair would like to call Arif Panju. And sir, if you don't mind stating your name, who you're testifying on behalf of, and if you are speaking on, for, or against the bill.
Thank you, Mr. Chairman. Arif Panju, Institute for Justice. We're for the bill. I think it's a good bill. I'm Arif Panju with the Institute for Justice. I'm the managing attorney of the Texas office. And at IJ, short for Institute for Justice, we represent property owners defending against civil forfeiture actions across the country. We've brought several constitutional challenges around the country to different aspects of forfeiture, including securing a 9-0 ruling in the U.S. Supreme Court in Timms v. Indiana, a civil forfeiture case involving the question of whether the Eighth Amendment's excessive fines clause applies to the states. It does. SCOTUS said 9-0. Quote, protection against excessive fines has been a constant shield throughout Anglo-American history for good reason. Such fines undermine our liberties. House Bill 928 by Chairman Dutton recognizes the same principle, that the use of civil forfeiture in the civil context, in civil courts, in the absence of a criminal conviction, but yet allowing prosecutors to wave around criminality in civil courts, undermines due process, undermines private property, and both of those are enshrined protections under the Texas Constitution's Due Course of Law Clause. Texans should not be losing their cash, their cars, their property under the mere suspicion that's involved in a crime, and to do so in the civil courts where prosecutors leverage discovery, the lack of counsel. I think you heard that they're entitled to attorneys. They're not, civil court, and then have to prove the property innocent. The burden is so low that a criminal conviction helps recalibrate constitutionally what's happening. I want to address some of the things you've already heard. I think you heard someone from Tarrant County say, quote, most crimes, quote, most criminals, quote, deter criminals. But they're here opposing a bill that would require scrutiny on the criminality of what's happening. You heard them say, quote, we don't let a criminal keep their profit, but they're not the judiciary. They're not the ones that get to decide. And they're here opposing. They're using criminality just like they use in court, just like they're doing here. But they oppose the scrutiny that the court would provide on whether there is criminality at all. You also hear that civil dockets will get overloaded or criminal dockets will get overloaded. Well, there's a stay of proceedings they're very, very familiar with. They can just ask for a stay of the case and get their criminal conviction. But pointing to loaded dockets isn't an excuse for fast-tracking forfeitures. It's a reason to slow down. Courts exist to protect constitutional rights. They don't serve as a fast-tracked civil forfeiture. We support this bill because the bill is well-intentioned. It is true that in this country, you're innocent until proven guilty, but far too many people show up in civil court facing discovery by prosecutors who are accusing property of being part of a crime and then find themselves in an unusual position of having to prove their property innocent while being accused of a crime while having no protections from criminal courts. Having criminal conviction helps change that. DAs should not be in civil courts. They should be in criminal courts altogether. But this bill is a step in the right direction. Thank you.
Thank you very much. Just a clarifying question, because you mentioned constitutional due process rights. How would you describe the interplay between constitutional due process rights and the application of current Texas state law as it relates to asset forfeiture?
There's several constitutional infirmities. When you step into court and someone seizes your property, you should have a prompt post-seizure hearing. You've been not arrested of anything. Nothing's been proven, but there is none under the statute. The innocent owners that you'll hear Representative Schaefer talked about, like the grandma situation, her burden is to prove that she had no knowledge of any act or omission. She has to prove a negative, something that's constitutionally problematic that the Supreme Court of the United States has made clear. The profit incentive at the heart of the statute is what drives and skews policing priorities, pursuing forfeitures instead of justice. There should never be a financial incentive in a direct budget for a DA or sheriff's office that's engaging in seizures and forfeitures. It should go to the General Revenue Fund. And finally, you have to have a recalibration. If something's being accused of being part of a crime, then you have to prove the crime actually took place before you move on to seizing the stuff, not the other way around. All of these are different species of constitutional infirmities with the statute under the Texas Constitution's due course of law clause and under the U.S. Constitution as well, and under the provisions that guarantee property from being unlawfully seized and forfeited.
Thank you very much. Any other questions, members? Thank you very much for being with us. All right, and I believe that concludes the testimony here. Are there any, is there anyone else who wishes to testify on, for, or against the bill before us, which is HB 928? Okay, if not, then the chair is pleased to recognize Representative Dutton to close on his bill.
Thank you, Mr. Chairman and members. This was predictable. I could have written this before you had all this. I mean, I knew law enforcement would come in and suggest that criminals will not benefit from their illegal profits. Well, what you heard was not true up here, because somebody got up here and said they have to prove the underlying offense. That's not the case at all. If they had to do that, that's what the bill does. That's what the bill says. You ought to at least charge him with a criminal offense and have a final conviction in that case. Now, about the only thing I heard that made sense was somebody got up and said, well, if a person has deferred adjudication, that means they admit guilt, but then the court withholds the finding of guilt. But let me tell you about deferred adjudication, and I do them all the time. Deferred adjudication has conditions, and if you made one of the conditions that they would forfeit whatever was seized, then that would be a condition of the deferred adjudication. And so all you'd have to do is say, well, that's a condition. And you either accept the deferred adjudication and relinquish your right to the property or not. That's the only thing that would have to happen. Crimes, and people got up here and tried to scare you with drug cases and bank robbers and all that, and suggesting that that had something to do with this. That has nothing to do with this. This only has to do with the rights of citizens to keep their property. And if the government's going to engage in taking it, the government ought to be on, we ought to make sure the government does that with all the protections that are afforded in our Constitution. And that's not what happens in civil forfeiture cases. What happens is we've thrown all the precautions out the window. I told you earlier about the case that where the Constitution says that, wait a minute, you ought to be protected from illegal seizures. That's not what happens in civil forfeiture cases. And so I appreciate law enforcement coming here, but as members of this committee, I don't think you'll have law enforcement coming down here ever to be for a bill that changes the way law enforcement conducts its business today. That's never going to happen. And in my 40 years of being here, it's never happened. And so with that, Mr. Chairman and members, I leave it with this committee. I told you I filed this bill 8 times. But the one thing about this time is you all are smarter than they are.
Can I ask one question, member?
Sure.
Is there any perhaps unintended consequence were this bill to pass of either an increase in incentives for criminals to engage in criminal behavior or a diminution of law enforcement's ability to keep our streets safe?
I think in answer to your question, there would never be an incentive for criminals to do anything in terms of changing the civil asset forfeiture law. Because I think the civil asset forfeiture law is right now, there is this idea that if you have a criminal conviction, that the asset forfeiture ought to follow the criminal conviction, not the criminal conviction follow the asset forfeiture. Because think about that for a minute. That means that your property is gone, you can go to court, and if you were found not guilty, your property is still gone. That's the effect of what happens now. You could go to court, you could prove that I didn't engage in the crime, but the law enforcement could have already taken your property and you can't get it back. Because there's nothing in the law that says they have to return it. That's the scary part. And so I don't think you'll have an increase in crime. I think law enforcement would have to adjust to the way it does things, but I don't think that would cause should be a real concern for us, because I think if we're gonna err on the side, we ought to do that on the side of the average person in Texas.
How would you articulate, Representative, the impact to, as you put it, the way law enforcement does things? What would be the operational impact to law enforcement in Texas were this to pass?
Well, I think what they would do is simply, if you pass this bill, that law enforcement would make sure that they at least had the right person for the right crime. If they're confiscating assets or property from a person, they would ensure that they at least had a sound case in which they could prosecute. And those cases would go and be prosecuted, and then you would have law enforcement, and I think you would have more civil forfeitures, because what would happen is, if you were found guilty in the criminal case, the person wouldn't even worry about the property. The person would just say, well, I give up. I'm not even going to be bothered with that because I've been found guilty, and now I know that the proceeds are there, but I don't have any interest in trying to litigate for the proceeds because I've already been found guilty in the underlying case. And the standard in an underlying criminal case is beyond a reasonable doubt. That's a higher standard than preponderance of the evidence, and so you've already had the basis for conviction on the higher standard. So on a lower standard, you obviously know that that's going to be done, so you would just give up.
Thank you very much. And I apologize for me delaying you in closing.
Oh, that's all right. That's all right. Thank you. I mean, this is so important because there are a lot of people. You heard from 2 people, 3 people here for the bill. And I don't mean this as a contest between law enforcement and criminals. That's not what it is. It's a contest between law enforcement and reasonable Texans. Criminals are still going to be criminals, and we're still going to have the basis and all the tools in our tool shed to deal with the criminals. And so with that, Mr. Chairman, thank you again.
Thank you, Representative.
Thank you.
Okay. All right, if there's no objection, HB 928 will be left pending. Is there any objection, members? Hearing none. HB 928 will be left pending. Okay, the chair would like to lay out HB 69 and recognizes Representative Schaefer to explain his bill.
Thank you, Mr. Chairman,
Thank you.
and members for being here. Give me the chance to lay this bill out. Let me begin by saying I bring this bill with a great deal of respect for our law enforcement officers around the state. I think that there has been a great travesty in the way some in our media and some of the public narrative about the job that our law enforcement officers do around the state, and that's not the spirit with which I bring this bill. There have been problems with the way asset forfeiture has been conducted in the state of Texas over the years. Isolated problems. I think most jurisdictions do a good job at following the law and the spirit of the law. But when those stories do pop up of a bad case where asset forfeiture is used, it paints a negative light on all of law enforcement. So I think that anything that we can do to tighten the standards around asset forfeiture, to avoid those bad cases that may happen from time to time, we're doing something to improve the public's perception of the way law enforcement operates. And I think that is a good thing. So my bill does two things. First of all, it raises the standard of proof from preponderance of the evidence to clear and convincing evidence. And then in all cases, it makes sure that the state has the burden to prove the case. So as you know, when you're involved in criminal activity, it's beyond a reasonable doubt. This is the highest standard in law. But the case in an asset forfeiture is preponderance of evidence, which is actually the lowest standard we have. What I'm asking to do is not raise it to beyond reasonable doubt, but to raise it to clear and convincing evidence, which is the highest standard we have in a civil court. It's still below beyond a reasonable doubt. Now, it's important to realize that they don't even have to charge someone with a crime. You heard Mr. Dutton's bill talk about whether you have a conviction or not. In an asset forfeiture case, you have to allege that there's a nexus between the property, it's actually called contraband in the law, and the crime, the criminal activity. There's got to be this connection between the property and the crime. But understand that in asset forfeiture, they can win their case against the property without ever charging someone with a crime, much less get a conviction. Let me read to you from a criminal court of appeals case, Fant v. State. It is not necessary that the owner or interest holder be the person charged with the commission of an underlying criminal offense. You don't even have to charge someone with a crime. And often the property is seized immediately and later charges could be dropped or, something happened with the case and charges are never filed. So that's how powerful this statute can be. Also, it's true that the person who's trying to make this innocent owner case, right, has the burden in court to prove the elements of the statute. Let me read to you from an appeals court case out of Houston. The bill is styled $18,800 versus the state. And this is at the appeal level. There is an innocent owner defense which provides an owner's interest in property may not be forfeited under Chapter 59 if the owner acquired and perfected her interest before or during the act giving rise to the forfeiture and did not know or should not reasonably have known of the act giving rise to the forfeiture or that it was likely to occur at or before the time of acquiring and perfecting the interest. The claimant making the innocent owner defense has the burden to prove it. One thing that we all know about criminal episodes is that the state always has the burden to prove their case, right? They're using the power of government to come and take someone's liberty. But in this case, when the elements are brought against the property and an innocent owner defense is raised, the burden is on the property owner to prove their case. And it's interesting, not only do they have to prove that they didn't know about it, they have to actually prove that they should not reasonably have known about it. So they're having to prove a negative and a hypothetical negative, that they shouldn't have reasonably known about it. This is asking the innocent owner defense to make a case about what they don't know. So the bill does two things simply. It says, raise the standard of proof to clear and convincing, because we've got a criminal act over here and it's beyond a reasonable doubt standard. So let's just raise it up to clear and convincing. And in a case where a person has to prove their innocent owner defense, that the burden is really on the state, where it should be in these types of matters. And that's all I have.
Thank you very much, Representative. Just a point of clarification for the members and others. In these civil asset proceedings, who or what is being charged exactly?
The property is being charged. It is called an in rem proceeding. And so when you get the lawsuit that's filed, they find the owner, or who they believe is the owner, and the case will be styled the State of Texas versus 1993 Ford pickup truck, or the State of Texas versus $18,800.
So a thing, an inanimate object is being charged. Is that correct?
It's a civil lawsuit against property.
And on the interplay of the presumption and the burden, is it possible that there's actually a double negative that must be proven here? That a property owner did not have knowledge, and also that the stuff did not, in fact, or was not used in the commission of a crime?
Well, the state does have the burden to initially prove the nexus, okay, that the contraband was likely involved in the criminal activity. So the state does have that burden. But if the person says, look, I'm not involved, I'm an innocent owner here, then that burden shifts to that person to prove the negative, that they weren't. And so what we're saying in this bill is that in both cases, in both elements of this lawsuit, the burden should always be on the state to prove their case, and that they're not able to say, hey, a crime happened over here, we think, but now you got to prove that you weren't involved. So
how does current state statute interplay with the principle of presumption of innocence?
Well, it's backwards. I mean, you can just read from the courts. It just says, this is an amazing statement straight out of the appeals court. The claimant making the innocent owner defense has the burden to prove it. And that's just backwards from what we normally have in criminal episodes.
And would you mind just maybe articulating just a little bit the practical implications of raising the standard from what it is to what your bill contemplates?
Jurisdictions that are following the law, that are only seizing property that was involved in a crime that they believe they can prove, will never change the way they do. If my bill passes, they will not even know it. I'm not changing what they can seize, when they can seize it, none of that. So I believe the jurisdictions that are doing a good job today will yawn and say, we don't even realize Schaefer's bill passed because we can continue to do the things the right way that we have before.
I think a statement probably would be true, although I can't speak for all 149 of my colleagues, but I think the vast majority, if not all, members of the Texas legislature want to make sure law enforcement has every tool they need to keep our streets safe. Any operational impact or adverse operational impact do you think might arise from this bill were it to pass on law enforcement's ability to keep our streets safe, A, and then B, what do you think would be the operational impact of your bill were it to pass for law enforcement?
Operationally, I think that if there are cases that are a little more questionable about the nexus between the property and a criminal activity, that district attorney's office may give a little bit more scrutiny. to some cases and say, our connection is a little bit looser than we think it should be, and they choose not to pursue that case. But I think in the vast majority of circumstances, it's not going to change anything about the way law enforcement operates. And I do want to note that this bill passed out of the House last session, but died a fateful death in the Senate. So,
I've never heard that story before. Thank you. Members, any other questions for the representative? Thank you very much, Representative Schaefer. All right, Chair would like to call Rebecca McIntyre. Thank you very much. And per usual, name who you're testifying on behalf of and on, for, or against the bill, please.
Thank you, Chairman. I'm Rebecca McIntyre with the Tarrant County Criminal District Attorney's Office, testifying on behalf of the elected Phil Sorrells, and we are here in opposition of this bill. The most important duty any prosecutor has is to see that justice is done, and we put our cases under strict scrutiny before we ever accept them for filing. We train our law enforcement agencies and officers to put their cases under strict scrutiny before they ever submit them to us. They can call us at any time and ask us to evaluate a case and see if we believe that they are going to be able to meet their burden of proving that property is contraband. In other words, that it is used or intended to be used, proceeds from or acquired with proceeds, or even facilitates the act of a crime prior to us ever thinking about seizing the property. And many times they call us before they've ever got out on the street to try to do anything with a suspect. No one wants to take property from an innocent owner unfairly. That is something we give strict scrutiny to, again, training our law enforcement officers to do this before they ever file a case. And when the case comes into our office for review before filing, we give it strict scrutiny. We have used the forfeiture statute on multiple occasions to return property from injured parties from respondents in forfeiture cases who actually acquired that property through illicit criminal means. Specifically, one case I can point to is a scam artist investor who took over $500,000 from one retired couple. At the time the property was seized, we knew he had been doing a scam for about 10 years, and we knew he had scammed many people out of tens of millions of dollars, but we couldn't tell you who it belonged to. We had 30 days to file on that property, or else it would be in his hands. Even after he was convicted of this crime, he continued to fight against the forfeiture case to obtain what had then been proven by forensic accounting methods to belong to these innocent parties. We joined with the innocent parties, saying we did not want to see forfeiture of that money. We wanted it to return to where it needed to go. If we had not done that, this scam artist, serving approximately 88 years in prison on a number of counts, would have gotten the money back rather than the retired couple who was out $500,000, their retirement savings. We've done the same thing with cancer victims who had had property taken by people unknowingly, even when that property or car had been seized twice. Shifting this burden puts us in position of what Mr. Panjud noted is problematic and trying to prove a negative. The only person that has the information necessary to prove that someone is an innocent owner is the innocent owner. They can show us where the property came from. We have no idea where to look, and even with discovery, that's burdensome and it drags cases out. If they can come and show us something, we might dismiss the case immediately after filing because they've given us credible evidence it belongs to them and it's not proper for forfeiture. There's no problem with us doing that.
Thank you very much. And I will say on a personal note, as somebody who represents a neighboring jurisdiction, thank you very much for what you and your office do to keep our part of the state safe. So thank you very much for that. What would be, from the practical or operational perspective, the impact to the Tarrant County DA's office were this bill to become law?
It shifts the burden of proof. As it stands now, we initially have to prove our case in chief, that the property is contraband and that it is linked to the underlying offense, which we also must prove. If we don't prove the underlying offense, we can't establish that it's contraband. Then you have the burden of proof shift at that point after we've proven our case, that we have contraband subject to forfeiture, for the innocent owner to come in and show they are in fact an innocent owner. This bill would first of all, change the burden of proof to clear and convincing, which is the second highest burden of proof. Our current burden of proof, is, as I noted previously, is used in all civil cases, regardless of value. Raising it up to a higher level, it is burdensome. It's not good public policy.
When you say it's burdensome, is there any way to sort of make that statement a little bit slightly more granular level? What would be the operational day-to-day impact on your office?
You know, it would remain to be seen, frankly. We are operating, and I believe most of the state is operating on a daily basis in a good and ethical manner on these cases. There aren't, and haven't been in quite some time, any bad headlines about forfeiture cases. If there are, then you handle that on a case-by-case basis. You don't take what's working and, so to speak, throw the baby out with the bathwater, the good out with the bad. You handle the problem if it comes up, and let's solve the problem, handle the abuse if there is an abuse. But there's not. We're all working to make sure that we get the property back to the people it belongs to.
Thank you.
At the conclusion of our case would be when the burden would shift, or does currently shift, to the innocent owner. They're not, as the bill may make it sound, they're not burdened with this at the beginning of the case. If we don't prove our underlying case, it never shifts to them to show that they're an innocent owner. They don't have to, because we failed to prove our case. If that's the case, the whole thing goes away.
Thank you. One final question. To pick up on your throwing the baby out with the bathwater analogy, are there instances where, in your opinion, there are innocent people who have been deprived of their property because of the implementation or execution of current Texas statutes regarding civil asset forfeiture?
I would never say never. I've learned that a long time ago. I am sure that there have been in history, but I can tell you that every law enforcement officer I know and every prosecutor I know, that goes against their grain and against their oath to see that justice is done. Bottom line is justice needs to be done, and we do everything we can to achieve that goal. And we are backed up by the courts, the judges. If it needs to go to trial, anyone, including an innocent owner or a respondent, a criminal defendant, can ask for a hearing before a judge or a jury in these cases. So there are backups and safeguards.
Thank you. Members? Yes, Representative Shaver.
Thank you.
Morning.
Do you think that an innocent owner, knowing that there is a nexus between the property and a criminal activity, even if they are truly innocent, do you think they would be nervous or worried about responding to any kind of request for admissions or putting anything? Can you see how that would put pressure on that property owner to not want to speak for fear of being implicated in something they were not truly involved in?
All I can do is speak from my own experience. And my own experience, an innocent property owner who feels that they have been treated wrongly by the system generally speaks out quickly and loudly. Sometimes they have expressed to me in doing so that, I didn't do anything wrong and I don't want anybody to think that I did. And I will always take that opportunity to explain to them they're not being charged with a crime. If they are in fact an innocent owner, we want to fix the situation.
How often do prosecutors use seizure of the asset and admitting in that case in order to get a plea deal?
That should never happen. That's why we need to keep our civil asset forfeiture separate from a criminal prosecution. If you are bargaining off someone's life and liberty and a risk to that by a criminal charge against their asset forfeiture property, that's a problem. Even in appearances, even if it's not in actuality, it's a appearance problem.
But you do know that happens routinely in the state of Texas.
I do not. I absolutely do not.
You don't think that prosecutors that are bargaining with a defendant raise the relinquishment of their property as part of a plea bargain?
I would not do that ever, and have not.
But would you acknowledge that does take place?
I have seen it maybe once or twice in my career of 30 years.
Okay, thank you.
Thank you. Members, any other questions for the witness? Thank you very much for being here.
Thank you.
Okay, Chair would like to call Devin Polk. Welcome back, officer. If you don't mind, again, name who you are testifying on behalf of, and if you are on, for, or against the bill.
Good morning, Chairman, members of the committee again. My name is Devin Polk, here today representing Dallas Police Department and the Texas Police Chiefs Association to testify in opposition to House Bill 69.
Great, thank you. Welcome back, and again, thank you for your service.
Thank you, sir. As I mentioned earlier, I'm the major of the Special Investigations Division, Dallas Police Department, including narcotics advice units, and administer the asset forfeiture program for Dallas Police Department. Asset forfeiture, as I said before, is a powerful tool for us to combat organized criminal activity by depriving these criminal organizations of the proceeds of their criminal activity. One organized group that, we routinely deal with in Dallas and that is involved with asset forfeiture is in the arena of human trafficking. These organized criminal groups and individuals within the state, they prey on our weakest and most vulnerable, forcing them into lives of sex or labor trafficking, as well as smuggling undocumented individuals into and through our state. These groups profit off and amass significant financial assets while costing the state billions of dollars and destroying or ending countless innocent lives. These assets provide traffickers lavish lifestyle while their victims live lives of involuntary servitude, squalor, and constant re-victimization. Passage of House Bill 69 will shift the burden of proof to the state and increase the burden to clear and convincing evidence from a preponderance of the evidence in forfeiture proceedings. This bill will significantly increase the overall cost of litigation to law enforcement agencies as well as district attorneys' offices by shifting the burden of proof from preponderance of the evidence to clear and convincing evidence. As an example, for the Dallas Police Department, we currently have 2 detectives assigned to the filing and preparation of asset forfeiture cases for the entire department. If this bill were to become law, the Dallas Police Department expects we will have to significantly increase the staffing of our asset forfeiture squad in order to meet the increased burden of proof. This would occur during a time when the Dallas Police Department is, like many other agencies in Texas, facing staffing shortages, recruitment difficulties, and are working tirelessly to combat violent crime. To also address some of the statements, and I can only speak for Dallas Police Department and Dallas County, but we ensure that we have criminal conduct in the form of an arrest before we initiate any asset forfeiture proceedings. That case is then looked at by our asset forfeiture squad. That case is then reviewed by the district attorney's office, and many of those cases are rejected and the property is returned. We do it right in Dallas County, and we ensure that we have those checks and balances in place that we can do this program to actually seize property from criminal organizations, to hit them in the pocketbook, and for us to be able to continue to combat the violent crime, human trafficking, and drug trafficking within the state of Texas. Thank you for your time. Pleased to answer any questions.
Thank you very much, officer. And a similar sentiment I express to the Tarrant County DA's office as somebody who represents a neighboring jurisdiction. Thank you very much for everything you do to keep our communities safe.
Thank you.
You made a statement at the beginning of your testimony that you want to deprive criminals of the proceeds of their criminal activity. I, for one, agree wholeheartly with that. And we want to make sure you are well equipped to do that. I have a question, though, in terms of who is it in our society, under current state law, who gets to determine who is or is not a criminal?
Ultimately, that is the judge, in the judicial system.
So is it the position then that, it is only adjudicated criminals that are having their proceeds taken from them?
It's not just adjudicated criminals, with them being 2 separate proceedings between the civil and the criminal.
Okay, thank you. Members, any other questions? Yes, Representative Chasline.
Once again, just like was said previously, thank you for your service. Thank you for all that y'all do. One of the things that I was just looking into, and really, as Representative Schaefer was sharing. So you said that the burden of proof would cause probably an increase in staffing. On a practical level, what would be the need for that if you're already doing it correctly? If Dallas is doing it correctly, you're already looking and making sure that you have the evidence to go forward and seize those assets. Why would there be such an increase to hire more staff with just this small shift in burden of proof?
So, thank you for the question. For starters, with that increased burden, because we have the separation in Dallas between our investigator, patrol officer, whoever's conducting that investigation, and the detective that's conducting the asset forfeiture side of it, with that increased burden, we may have to dive deeper into these cases that under a preponderance of the evidence or truly probable cause that we were able to make that arrest to even start this proceeding, we're now having to go to that higher burden. We may have to start investigating bank records on something that's a clear-cut case where somebody, through a narcotics investigation or a human trafficking investigation, we have countless hours of surveillance. We have all of these facts that will, under preponderance, it's clear-cut. We even have probable cause to obtain an arrest warrant for that individual. We've now raised that burden of proof. Now are we going to have to get, bank records? Are we going to have to dig so much deeper into this case when truly it's unnecessary? We had the proof prior. Raising that up to clear and convincing is going to cause more resources to be spent.
And just a follow-up question, but once convicted, those assets can be seized, correct?
I guess I don't understand your question.
Sorry. So
Sorry.
When speaking on these assets that you're seizing, once the conviction comes, those can be seized either way, correct?
They can be, but they're two separate cases. So that civil proceeding is going with the criminal case moving over here.
Okay, got it.
Is there, just to pick up on a question that I asked a previous witness, admittedly on a previous bill, but the question is applicable here, trying to get the legislature's mind around sort of a quantification or the scope of this issue in the state of Texas. I think one witness earlier today testified there's approximately $34 million that moves through the asset forfeiture channels, and we don't have a lot of granularity about how that's broken down. Are you able to provide, at least from the Dallas counties, office understanding roughly what percentage of the funds that come into you through forfeiture proceedings follow a criminal conviction of any kind?
I don't have those numbers with me. I apologize.
Rough idea?
I don't, sir. I'm sorry.
If you do have it, I would be curious subsequent to the hearing.
Yes, sir.
Thank you very much. Any other questions for the witness? Thank you very much, sir, for being here. And again, thank you for your service. All right, Chair would like to call James Smith. Welcome back, officer. Thank you again for your service, for being here, and name who you're testifying on behalf of and if you are on for or against the bill.
Thank you, Mr. Chairman, and the rest of the committee members. Once again, my name is James Smith. I'm a sergeant with San Antonio Police Department, and once again, we do oppose this bill. If you wouldn't mind, I can kind of answer that question that you just asked.
I'd be most appreciative.
Yeah, every one of ours does have an underlying offense. Now, I cannot tell you how many of those have final convictions. As they had stated before, they go on two different tracks. There's so many issues that can change. They could be working with the state, they can turn state's evidence, or they flee. A lot of these individuals flee the jurisdiction, and you'll still have the final adjudicated case because these get publicized in the newspaper and other means to try to get them served.
Just be real quick for clarification. Every one of yours has an underlying, you said offense. There's an underlying allegation of an offense. Is that correct?
Yes, it does. Yes, it does. Because if we don't have that at the beginning, we're not going to file it. And I'd like to segue off the district attorney's testimony earlier. We are the filters. We're the filters before it even gets to the DA's office. The patrolman on the street will get a case. We'll look at that. We'll even see if it meets the minimums. It has to meet that Chapter 59 nexus. If it's a DWI-4, but they seize money, obviously that money has no nexus to a DWI. That money is immediately released. We look at the registration immediately. Hey, who's this car belong to? And as the district attorney had said, these people are calling up pretty quick, but we are very proactive on the thing of we don't want to have these people's evidence tied up. If it's a family car or something like that, we'll make sure that car gets released. And remember, as it's sitting in there as evidence, there's no storage fees or anything like that, because it is considered evidence at that point in time. But we are the filters. And then when we file a case, we send that up just to the DA's office, and we will have those exact same discussions and say, hey, do we have a good case here? The last thing we want to do is take any innocent owner's property. We go very granular in those reports, in those reports, and saying, where was that money found? Okay, this money was found in the back seat with this passenger who had nothing to do with the narcotics. That money's being released probably that next day, next 2 days, or if it's over the weekend, it'll take place later on. I took this oath, if you'd say, it's always better to let, several guilty people free than ever convict a innocent person. That is exact same mentality we use on our forfeiture cases. And I would just digress once again. I believe how Chapter 59 is set up now, it has been vetted, it's in good shape. We don't need to make there's no systemic problems out there that you may hear of. We are very good guardians of people's individuals' personal property rights.
Thank you very much. I for one, greatly appreciate several sentiments expressed in your testimony here. Given how, for lack of a more formal term, how buttoned up you are representing that you guys are down in San Antonio, and I have no reason to not believe you, by the way, and thank you for that. Help me understand how switching from a preponderance standard to clear and convincing would be that much of an operational impact, given that you already, as you just testified, you're not taking innocent people's stuff. You don't want to take innocent people's stuff. You've got an underlying crime that you believe was committed by somebody who, at least from your perspective, would be guilty.
Well, guilty is different. You're talking on the criminal side versus that of the preponderance. It's just not necessary at this point in time. The changing, I don't even know. I only know of a couple cases where clear and convincing is used. I'm not an attorney. The only places I know where clear and convincing evidence is used is in child custody laws and patent laws. And this just goes counter to the whole civil process. We are filing exactly what you're saying. It's a lawsuit. It's a tort. We're filing a lawsuit against that 1983 Chevy or that $10,000. It is a lawsuit. So it's changing so many other things. If it was broken, if the system was broken, I go back to that. Hey, we're all about fixing it. There are some outliers, but I can tell you from our jurisdiction, I know other jurisdictions. I'm just surprised the whole margarita machine didn't come up that was seized 20 years ago. We always hear that same story. People have this thing locked down. This law, Chapter 59, has been vetted for many years, and I believe it works.
I'm too new to know the margarita machine story. But
oh yeah, I'm surprised it didn't come up. You'll hear it if you sit on the subcommittees.
Okay, but your position, I just want to understand it, just to switch, given how buttoned up you guys are, when you enter, not just on the criminal side, but on the civil side, and to taking an action against an asset, contraband, I'm still not quite hearing what would be the operational impact.
I don't know how to answer an unknown, and that's part of it. I just know that under what the parameters we're working at now work, and I know the protections are there. It's just impossible to understand what the unknown is. I just don't see the necessity for a change because things are working, they're working properly. People are protected. Their due process is they're seeing it both on the criminal side and our side. And there's so many things that can take place on the criminal side. As I said earlier in my other testimony, if we lose that evidence on the criminal side, our case is done. But we are very cognizant of innocent owners' rights. And that sounds like that's one of the biggest issues we have I'm not either side of the political spectrum. That's just good business. You want to take care of people's personal property rights. We're not just knocking down doors and taking people's property. There are these underlying offenses. I'm sorry, I can't answer your question specifically because it's an unknown. Yeah. But the known that we have right now is working.
I just want to make sure that I'm understanding correct when you say there is, when it was stated as definitively as you just did, there was an underlying offense. There's an allegation of an underlying offense that's not been adjudicated by any court. Is that correct?
Exactly. We have to have that, or we're not getting the case. We have to have that. If there's not, for example, an officer stops a car as a criminal instrument because he has dope in it. Say it's not dealer amount of dope. Okay, we can't file it because that doesn't meet Chapter 59's nexus. So what we do, obviously, we don't give the dope back, but the money would be sitting there, and that money would be given back because it doesn't show dealer amount. So those are the types of things. Like I said, my example of a DWI 4, the money has absolutely nothing to do with the DWI. We're going to seize that vehicle, obviously, for the DWI 4 and file on it. And then he's going to go through the courts on the DWI charge. But
Thank you. And they're just points of clarification, because when I hear, and I've heard many times today, that there was an underlying offense. A criminal did something and got proceeds from their criminal behavior. It's just a question of who adjudicates these terms in the state of Texas. And that's why I'm asking some of these questions.
And there's a lot of confusion. You'll hear a lot of testimony up here. And there are cases where the federal government does things. They'll just take the money. But that's the federal government.
I have one or two beefs with the federal government as well.
Well, they take our taxes too, so. and like I say, I always look at this too. It's not a huge moneymaker. That number sounds like a huge number, 34 million. That's not even hardly any. If we had that whole 34 million, our budget, our police budget's, over $1 billion a year almost. It's crazy expensive. So, but this does help give the ability of the chief to maybe get some new equipment. Send people to training. It's a good, this is a good tool that we have.
One, Representative Schaefer for a quick question.
Thank you. Just to clarify, you're saying that in your department, in all cases, you will not file an asset forfeiture proceeding unless a criminal charge is going to be filed? There's
an arrest. We have good cases. There are some money laundering cases that take time, and they'll file on them at large. Now, we're not talking arrest is made right then and there. Okay. But we will not file that case unless there's an underlying criminal charge, and we have probable. If they don't have probable cause to arrest, we don't have probable cause to seize.
So are you saying that there are none of your civil asset forfeiture cases proceed without somebody being charged with a crime at some point?
No, we start proceeding because we only have the 30 days.
Right.
If we don't file on that, it could be $2 million.
Even after the 30 days.
After 30 days, that loses its status as coming.
Right. But you're telling me that none of your cases, you file against the property, and there ultimately is never a criminal charge filed, but you continue the case against the property.
There could be on money laundering cases where they file on them at large.
Right.
And they have a lot more time on the criminal side to do that. We have 30 days.
Right, but I'm saying, are there
We have to have that, 100% of our cases have that nexus. It has to meet that burden. It has to be either, felony first or second degree, I won't remember them all, or it has to be one of our enumerated offenses.
Are there not cases where you're not sure who the owner of the cash is, and you still file against the cash and nobody ever gets charged?
On those, if we don't know who the owner is, we don't take those cases.
You don't seize?
If someone just comes by and says, hey, there's a bunch of cash here, that's abandoned property. Okay. That's abandoned property. We can't file. We have to have a respondent.
Okay, so even in cases where you do a traffic stop and maybe somebody consents to a search and they were driving somebody else's car and there's a duffel bag full of $100,000 in the back, y'all are not seizing the $100,000?
Not unless we can prove there's a money laundering case, and there has to be a lot of mitigating circumstances. Okay. And that there has to be ledgers, a dog hit. There's a lot more evidence that goes into it.
Okay.
And some of these people may say, I have no idea what that money deals with.
Do you think it's possible in some other departments that they proceed against that money without charging anybody?
They're not going to win the cases. I know in the old days that used to take place a lot. There used to be a waiver where somebody could write, and that's no longer can you do that, saying, hey, I have nothing to do with this money, but you can have it. That you can't do that anymore. But yeah, there were a lot of things that were done in the past, but things have tightened up. And I can't speak for these jurisdictions, but I have a lot of faith in my counterparts in this room that they're doing it the correct way.
Thank you. And just, we are getting very tight on time here, so
Oh, I'm
don't
sorry.
mind following up offline, maybe with his office. So thank you very much.
I appreciate it.
Any other questions for the witness, members?
Thank you.
Thank you very much, and thank you very much again for your service. Okay, Chair would like to call Derek Cohn.
Thank you, Mr. Chairman. Derek Cohen, Texas Public Policy Foundation, speaking in support of HB 69.
All three of the things, thank you.
Yes, and I'd like to point out that a lot of the examples have been fleshed out on this particular bill already. So many times, witnesses themselves have admitted that there was an ultimate criminal conviction. So simply raising the civil standard, which upon criminal conviction, the bill we heard previously wouldn't even take it to that because it still would have kept the actual Article 59 in place. This simple says keep everything civil and just raise that burden ever so slightly. I also appreciate Representative Schaefer's work on the innocent owner side of it. But another thing that we've had is that we've heard is that these agencies here, and I have worked with many of these agencies, these are good agencies. Don't let anyone tell you otherwise, that the agencies that have the capacity to actually come up to the legislature and talk to y'all about this, aren't making sure that they're run very tightly. They are the ones that are doing the right thing. Now, the problem, of course, being is that our rights don't exist simply by the whim of a state agency or a state actor. And so that's why certain safeguards, such as the one posed in HB 69, need to be in place. We also heard the talk of the budget side. I do want to point out that under Article 59 current law, right now, you are not allowed to actually budget for any anticipated forfeiture proceedings. So the idea that this would somehow defund the police or anything like that is completely misstated. In fact, after HB 1900 from last session, or I'm sorry, from the 87th regular, after that bill, it is actually illegal to defund law enforcement, as certain agencies are now kind of coming to grips with. So again, you can't budget for the anticipation outlays or what would be a Chapter 59 expense. Now, I do appreciate the officer mentioning the margarita machines. Those are talk about, like, it's kind of like it's a meme in certain circles. Now, that's on the what is the money spent on side. Now, what the money is spent on side, I'd like to, again, maybe replace the margarita machine with the $700,000 in laptop bags, the $150,000 in toner cartridge, dozens of thousands of dollars in parking and conference registrations, things like that. That's a different bill. That's not this one. That's what it's spent on. That's a different bill. That'd be a reporting bill. So all that to say is some of the other testimonies that we've heard is that some of this will incentivize more criminal prosecutions. Now, I've been doing criminal justice reform here in Texas for about a decade. I've done criminal justice reform with the Trump administration. And I'm saying the individuals that are on the other side of these allegations should be charged, and they should go to jail for a very long time. Criminal justice reform guy, send these people to prison.
Thank you very much for your testimony. I guess one question I would have is there has been numerous witnesses come up and testify that there would be, despite an inability to quantify it, an increase in resources that law enforcement might necessitate were this bill to become a statute. Given the interplay between the proposed bills and core constitutional rights and liberties, from your perspective, how much weight should the state place on the cost of ensuring somebody's civil and constitutional liberties are protected?
To be honest with you, sir, I come from a conservative think tank, and we are very, I think calling TPPF hawkish on spending would soft sell it some. Government has very few core functions, and public safety is, first and foremost, one of these states' core functions. Now, ensuring the due process, that is also a core function of the state. If it does, and I'm not saying it is because I fully believe it will not, have a delta between what it takes to enforce a clear and convincing evidence up from a preponderance of the evidence standard, I don't believe it'll take that much extra to enforce, because if it does, that's an indictment on the shoddy cases that are getting advanced. And I don't believe anybody in this room is advancing those cases. And so, again, the folks that I think need the scrutiny on this, they're not here to talk to you about this. But again, we can't just trust the better angels of our nature to manifest our rights into existence.
Do you accept the premise that this would necessarily result in increased resources for law enforcement, and even if that were the case, would that change your position on the bill?
No, it wouldn't. All right, let me answer that in two questions. Do I anticipate that being the case? No, it is not. Would somehow that change my position on the bill? Absolutely.
Real quick, can you say why you do not believe it would result in an increased need for resources for law enforcement?
Absolutely. The slight delta in the civil standards from preponderance of the evidence to clear and convincing evidence, that is a minuscule amount. In order to prove a case to clear and convincing evidence, we're still talking in a forum that has none of the criminal protections, so you're not getting into indigent counsel, you're not getting into any of the other protections we talk about on the crim pro side. In doing so, it would just have to satisfy more than a judge looking at going, yeah, I guess, set this on the roof and it rolls off one way. You would actually have to have more substance to that. And for that to be the case, not only in the places not represented here, but even in this room, there would need to be under current law, the advancing of highly dubious forfeiture motions against these properties. And I don't believe any of the people here are doing that.
Even if it were true, for the sake of discussion, that it would increase their resource needs, would that change your position of the bill?
I want to nuance that. Sure, yes, it would. But I also want to nuance that this is a secondary function of law enforcement. Making sure that property is forfeited to the state is not putting bad guys in jail and keeping us safe. At the very least, not directly, and I would argue indirectly as well. So if that could be shown to me, and I've been studying this for an awful long time, I'd be more than happy to change my position on the bill were that ever to come to pass.
Thank you. Members, any other questions for the witness? Thank you very much.
Thank you.
All right, Chair would like to call Arif Panju. Welcome back, and if you don't mind, name who you're testifying on behalf of and for, on, or against the bill.
Good morning, Mr. Chairman. Arif Panju, Institute for Justice, testifying in support of the bill, HB 69. The protections for innocent third-party owners under the civil forfeiture statute are very poor. The burden of proof that the state has to satisfy under the forfeiture statute is very low. These are two different things, and it's important not to conflate them. I'll start with innocent owner, because we've heard the grandma example. Grandma lends a car. I actually spoke to a father who lent his car a few years ago in Tarrant County to his son, drove to see a relative, and the car got seized along with other vehicles in the driveway of that house. The relative got arrested, but the son got let go. And I spoke to the daughter of this man who had stage 4 cancer and was trying to get her dad's truck back so he could paint, because he was a painter. And I've seen the emails. The assistant DA there was asking the daughter of this man to prove that he had cancer. She was holding a handful of written discovery requests. They knew that they dropped the charges against the son, but still wanted the car. A true innocent owner like Mr. Olvera, that was his name, shouldn't have to prove that he's sick or that he doesn't know something or hypothetically should have known but doesn't something, because that's what's problematic, is to saddling the individual that has the liberty with that burden. It's not problematic to place the burden on the government. They're the ones with the police power. They're the ones that have to justify their deprivation of liberty and property under the Constitution, not the other way around. This has real consequences. Mr. Olvera, ultimately at the end, just was scared that as he was dying, would get his son in trouble. So he just said, let him keep the damn car. That's the last thing that we heard from him. These are the real consequences. These aren't these one-offs. This is classic abuse of a statute where you're accusing criminality, using civil discovery, and forcing on innocent owners a burden that they should never bear. Mr. Olvera was not even in the town. He lent his car to a relative, and it should never, ever be his burden to prove that he did not know something. I could ask all of you to prove that you're not going to eat a burger at lunch, and you might come back with receipts of what you did eat at lunch. It still doesn't prove that you didn't eat a burger at lunch. It proves that you ate something else. It doesn't prove that you didn't do something else. That's the problem with proving a negative. Now to the main burden, the burden under the statute that there's a nexus to a forfeitable crime. That's the burden that law enforcement bears. These forfeiture petitions saddle up like spaghetti in the wall every single crime you can imagine under the forfeiture statute. I've seen petitions that allege that there's a nexus to, quote, criminal activity. It's not even a crime, just some activity somewhere that maybe some judge can figure out, but it's never proven. Preponderance is so low that these things get default judgment in the state's favor. And in a case right now in Harris County, just to give you a for instance, there's a case against Cash where there was no arrest made. In fact, they gave the loaded gun back to the property owner and sent him back on I-10 back to Mississippi. It's IJ's case. But they're going all in, saying they have probable cause and preponderance to prove that the cash is contraband. Not the gun. Under oath, they said the gun, no probable cause. They can give that back. On the side of the road, this is a cash making machine. And I'll end with this. It's why you heard the admission. It's not a huge moneymaker, but it is a moneymaker. That's the problem. And that's why you see these abuses, and they'll continue unless you start doing things like HB 69 and get good reporting on the books.
Thank you. Quick question, maybe sort of the flip side to a question I asked a previous witness when I was discussing who adjudicates claims of a criminal offense, or who is or is not a criminal. Is it your contention that innocent people are being deprived by the state of their property under current Texas state execution and operationalization of current Texas statute?
Absolutely. I've met them, I've spoken with them, and we fight for them in court. And I have one right now in Harris County who would like his life savings back. He would like to be a trucker, owner-operator, not just a trucker driving other people's trucks, but he lost his life savings on the side of I-10, got his loaded gun back, and was sent back to Mississippi, but not with his life savings.
These are people that you do believe were, in fact, innocent of any underlying crime, not simply that they committed a crime, but the state has not established it.
That's right. They're innocent, just like Mr. Olvera up in North Texas when he lent his car to his son. These are innocent Texans or people that come through Texas that don't deserve a statute that violates the Constitution and has to be constitutionally recalibrated in favor of liberty. We can't compromise the Constitution.
Thank you. Members, thank you very much.
Thank you.
Okay, the chair would like to call CJ Grisham. And I need to know that it looks like you have registered twice.
I tried to change it to testify because I think one of them was not testify.
So we'll delete the one that says not testify.
Yes, sir.
Okay, thank you very much. A name, who you're testifying on behalf of, and on for or against the bill, please.
Thank you, Mr. Chairman. Thank you, Representative Schaefer, for bringing this bill. My name is CJ Grisham from Temple, Texas, and I am here to testify for this bill. I am a retired Army First Sergeant, but I also recently graduated law school, and I'm a pending civil rights and gun rights attorney, just waiting to get sworn in. And so this is an issue that I care very deeply about. I would like to also remind this committee that when we signed up to testify, we had to check a box that said we would be honest and that we would not lie to you. I would submit that you've been lied to already today, and that is a department came up here and said, oh, we have to have criminal charges before we file anything and take anything. Well, tell that to the lady that flew in from Chicago just barely a year ago and had $106,000 taken from her suitcase because a dog sniffed the money. And she's never been charged with a crime. She still doesn't have that money back. And that same department came up here and told you that that never happens. Well, there's one example. I don't want my testimony to sound like I don't like cops. I come from federal law enforcement. I'm retired Army special agent. I did national security crimes, sabotage, treason, sedition, espionage, all that kind of stuff. That's what I did. So I'm very critical of bad policing. The police are an arm of government. And so when I criticize the police, I'm criticizing government. There's something in law called Blackstone's ratio. Blackstone's ratio states it is better that 9 guilty people go free than 1 innocent person be hammed up. That's paraphrasing. 1 innocent person be locked up, their freedom taken from them. John Locke talked about life, liberty, and property, which was changed into life, liberty, and the pursuit of happiness in our Declaration of Independence. It should be difficult for law enforcement and government to take someone's property. It's one of the highest assets and freedoms that we have in this country. If you are going to take something from a citizen, there has to be a reason for it. And you heard today that maybe it happens a little bit, maybe it doesn't. Whether it happens once or it happens a million times, it shouldn't happen once. And we should always protect, because to that one person, it's every time. Whether it's that way for the police or not, to that one person, that's his $106,000. That's her 2003 Dodge Grand Caravan or whatever it is. There was a veteran that was traveling. He was trying to open up a new business traveling west and had $60,000 in his car. Got pulled over for a simple traffic infraction. Asked, hey, do you have any money or drugs in the car? He says, he's got money. $60,000 confiscated, West Texas. Why? No charges, didn't do anything wrong. It's not illegal to carry $100. It's not illegal to carry $106,000. So I ask you to support this because this is in the time that I had my limited license, which expired, but now I'm waiting to get sworn in permanently, I've handled 5 civil asset on gun issues where they've refused to return a firearm, even though there's no charges. So this does happen, and it's got to stop, and I think this bill will do that. So please push this out favorably.
Thank you. Members, any question for the witness? All right, thank you very much. Chair would like to call Jacob Putnam. Good morning, sir. If you don't mind just stating your name, who you are testifying on behalf of, and if you are speaking on, for, or against the bill.
Good morning, Chair and committee members. I'm Jacob Putman. I'm the elected district attorney of Smith County, Texas. I'm here in favor of the bill. I think I covered all 3.
That's all 3. Thank you very much.
Sorry, Representative Dutton's not still here. He said no member of law enforcement ever testified for asset forfeiture reform, and here I am. I didn't want him to miss that opportunity. I will try to tailor my comments based on what I've heard so far. I, like the law enforcement officers here, agree that asset forfeiture is an essential and necessary tool for law enforcement. It's incredibly important. Disagree with the policy foundation that it is not part of their primary task because it's one of the best tools we have to combat crime, especially cartel violence. The cartel frequently loses shipments of drugs over the border, and they don't care about that. What they care about is their profits moving back, and seizing those profits is essential for Texas in order to help keep us safe. I'm in favor of the bill because while it does raise our burden, I do think, to the chair's questions, I do think it will make our job a little bit harder. The police will need a little bit more evidence, and district attorneys like myself will need to do a little bit more work to reach that burden. How to quantify that? That's case by case. But I can tell you when you raise my burden, you make it harder, I'm gonna have to do more work. I can live with that. I can understand there are concerns that not everybody in Texas does asset forfeiture maybe as well as they should. I know in Smith County, we do a very good job, and I have no doubt these law enforcement officers do too. Can I say that for the rest of Texas? No, I can't, because I don't work there. So raising this burden, would it strengthen a little bit the protections for the citizens? Sure. Would it make my job a little bit harder? Sure. But I didn't get into being a district attorney or prosecutor because I wanted an easy job. If you make it a little bit harder, we accept that burden and we're willing to do it. Like I said, I think this is a common sense restriction. Raising the burden and shifting the defense, innocent owner defense to the prosecutor, I think makes sense. There are many unworkable solutions out there, like requiring a criminal conviction. I can talk about that if the committee is interested, like setting a floor for a minimum amount to seize. Those things really are impractical and would defeat the good work that law enforcement is doing. But this bill, I can live with, and that's why I'm in favor of it. I'd be happy to answer any questions.
Thank you, and thank you very much for your service in law enforcement. Members, any question for the witness? Thank you for being here.
Thank you.
Okay. Is there anybody else who wishes to testify on, for, or against HB 69? HB 69. If not, the chair recognizes Representative Schaefer to close on his bill.
Thank you, Mr. Chairman. Members, I close.
Thank you. All right, if there's no objection, HB 69 will be left pending. Members, any objection? Hearing none, HB 69 will be left pending. All right, this time the chair, acknowledging some time constraints, let's go ahead and start on this and lay out HB 1442, and I would like to recognize Representative Ann Johnson to explain her bill.
Good morning.
Welcome,
Thank you.
Representative.
Good morning, and thank you, Chairman Harrison, Representative Schatzline. It's good to see you this morning on House Bill 1442. What House Bill 1442 is a adjustment and correction to legislation that was passed last session, which is Senate Bill 1495. This was a bill that was passed by Senator Joan Huffman in the Senate and Representative John Turner in the House. And it addressed the issue of street racing, or what we're seeing now as these street takeovers. The intent of the bill was also to allow the element to seize the vehicle that is used as the instrument of that crime in that circumstance. This bill addresses the technical fixes that was not done in last session's bill to include and provide the ability to seize the vehicle out of these circumstances in this offense. I will say, based on the testimony that I've heard from some of the others, these are not just vehicles that somebody is borrowing as they're potentially committing another crime. This is the instrument of the crime itself. As we saw a few weeks ago here in Austin, when these groups get together, the vehicle blocks the intersection, kicks gas on spectators that are there. It can be effectively a weapon that can hurt other individuals. And so this bill contemplates that increased element of having a prior conviction for this kind of offense of street racing, being intoxicated at the time that you commit this offense, or you cause injury to one of the spectators that is out there. I would ask for your favorable consideration on this bill, the right to close, and I do believe we have witnesses here to testify on behalf.
Thank you very much. Members, any questions for the witness? Hearing none, let's move to testimony. And the chair, what do we have? The chair would like to call John Carroll, please. Officer, welcome back. Again, thank you for your service. And if you don't mind, name who you are testifying on behalf of and if you are speaking on for or against the bill.
Okay, my name is John Carroll. I am here representing the Harris County Sheriff's Office, and we are for the bill. I am currently assigned to the Traffic Crimes Unit of the Harris County Sheriff's Office. I work alongside with my counterpart, Sergeant Fred Gomez with the Houston Police Department. We currently combat these street takeovers, intersection takeovers, street racing on a nightly basis. We've been doing this for 2.5 years. We've arrested over several thousands of participants. As y'all just witnessed, our communities are getting burdened with these types of criminal behaviors. Just last week, we had a Texas 2K event. It was a street racing takeover event. We arrested over 230 people in 4.5 days of work. It's dangerous for our community when these guys take over intersections and we have spectators. There's many people often hurt, injured, killed. They damage people's personal property. They damage our roadways that we pay for with our tax dollars. These guys don't need to have these vehicles. They're used as criminal instruments. But since, as a representative stated earlier, when that new law was in effect, it took some of the teeth out of the law, but this law brings the teeth back and it helps us remove these vehicles from these people doing these stunts.
Thank you. I think everybody would agree that street racing is incredibly dangerous. Why do we think this needs to be moved over to the civil side, and why can't the criminal proceedings say?
I'm sorry?
Why is the criminal side insufficient to handle this problem? Why do we need to move this into the civil side?
We need to remove the property from the suspect or the defendant, so you can't do this again. We have.
But it's your position the criminal proceedings are insufficient.
Correct.
Okay.
And the reason being is Sergeant Gomez can testify as well. We've arrested the same individuals over and over and over again participating in these events, and you know, since the law changed, we haven't been able to take their vehicle. It's not that we really want to, but it takes the criminal instrument out of their hands to prevent them from doing it further.
And no, but just to be clear, since this would be moving to the civil side, you would be taking property from somebody without anybody being convicted of a crime. Is that correct?
Correct. Okay. Criminally charged.
Without that, in this case.
Right.
Okay. Thank you. Members, questions for the witness? Thank you very much.
Thank you.
Chair would like to call Francisco Gomez. Officer, welcome. Thank you first and foremost for your service. Thanks for being here. If you don't mind, name who you're testifying on behalf of and if you are on for or against the bill.
Will do. Thank you, Mr. Chair, members, and thank you to our sponsor, Representative Johnson, for this. My name is Francisco Gomez. I'm the sergeant of the Houston Police Traffic Crimes Task Force, aka Street Racers. I'm representing the Houston Police Department, and today I just wanted to read, like Representative Johnson said, in Senate Bill 1495 in 2001, I had the honor to be here in the House to help pass that legislation.
Clarification, did you say you were for the bill?
For
the bill. Thank you very much.
Officers have been using deadly conduct as a statute to seize cars, engaging in street takeovers when appropriate. However, in the 87 legislation session, a new, more specific offense of reckless driving exhibition in the Penal Code 42.03F was created. The legal concept of impertinent material requires that the violator must be charged with the most specific charge available unless language exists at the law that would allow officers to charge any applicable law. Because the new law, more specific offense of reckless driving exhibition contained in Penal Code 42.03F, police cannot use the charge deadly conduct as a basis for the asset forfeiture seizure in some circumstances. So the problem that we're trying to address here is the issue that the new reckless driving exhibition is not enumerated offense under the engage in organized crime, so it cannot be elevated into Chapter 59. The reason I support this, and you're here as the Houston Police Department, is because organized street racing and street takeover continue to plague Houston and also Harris County, the state of Texas, and all over the nation. So addressing this unintended consequences will allow officers to seize vehicles and when it's appropriate.
Thank you very much. Members, any questions for the witness? Thank you very much, and thank you again for your service. Okay, Chair would like to call Jeff Hunter, please. Thank you for being here. Thank you for your service. And if you don't mind, name who you're testifying on behalf of, and if you are on, for, or against the bill, please.
All right, I am Sergeant Hunter with the Dallas Police Department. I am here in favor of the bill.
Thank you very much.
Before I begin, can I hand out some flyers to you?
Please.
All right. So I was in charge of the street racing task force in Dallas from 2021 to 2022. Prior to working with the task force, I was assigned to the Crimes Against Persons Operations Support Team, where my sole task was to arrest murder suspects. Prior to that, I worked with Project Safe Neighborhood, and along with the FBI Violent Crime Task Force, where we were tasked with apprehending violent robbery suspects in the act. Both were dangerous jobs. Surprisingly, being in charge of the street racing task force was by far the most dangerous position I've ever held as a police officer. I've been surrounded by hundreds of spectators with a mob-like mentality, had fireworks shot at me, objects thrown at me, lasers pointed at me. Takeovers are pure chaos. I had no idea what a takeover was when I took the position or what I was getting myself into. I assumed I would be dealing with kids doing donuts, but let me tell you, I was wrong. During my time with the task force, I seized hundreds of guns, several kilos of drugs, hundreds of stolen cars. We uncovered auto theft rings that started federal gun and fraud investigations. I learned these takeover events were attracting hardened criminals and not just immature kids. As I immersed myself into the assignment, I quickly learned that these events were highly organized, and we didn't have the laws to deal with it. We were having 4 to 5 takeovers a night, nights a week, and 7 to 10 takeovers a night. I learned takeovers are organized through social media, generally on Instagram. Initially, I thought if I could prevent the word from getting out, that the takeovers might stop or at least be slowed down. So I tried reporting the accounts to Instagram, and those requests fell on deaf ears. And while new state laws were enacted during my tenure, they were difficult to utilize and didn't really address the problem, the organizers. Eventually, we discovered a secret and found a way to end takeovers in Dallas. We began targeting organizers and performers, or sliders as they're known, which is exactly what this bill proposes. We haven't had a real takeover in Dallas in over a year. We earned a reputation amongst the takeover crowd as a place not to conduct takeovers. To this day, they still target our surrounding cities, but they won't enter Dallas. So while we continue to address the spectators with city ordinances and new state laws, our main focus became turned on the sliders and the hosts, which is how we turned the tide and ended takeovers in Dallas.
And I, with sincere apology to the witness here, we've got a time constraint because of the floor that we're all supposed to be at. So the chair, I'm sorry to do this. Go ahead. No, go ahead.
He can still testify when he's going to leave
When
it
we
pending.
return. Yeah, correct. I'm just going to move that we leave HB, what are we at, 1442 pending. Any objections, members? Hearing none. The chair also then moves that the committee stand in recess until final adjournment or recess of the House or during the bill referral if permission is granted. Is there any objection, members? Hearing none, the motion prevails and the committee stands in recess. Very sorry about that. Okay, the time is 12:07 and the subcommittee on asset forfeiture will come to order. The clerk will call the roll.
Chair Harrison?
Here.
Representative Christina Morales? Here. Representative Schatzline?
Here.
All right, a quorum is present. As a reminder, anybody wishing to testify before the committee, please register at the kiosks located in the hallways behind the hearing rooms. If you require assistance in registering or testifying, please contact the committee staff. And the chair would like to lay out HB 1442 as a matter of pending business and would like to call Jeff Hunter, who was previously testifying before we had to recess, if he is here. Jeff Hunter. Okay. All right. Is there anybody else here who wishes to testify on, for, or against the bill, which is HB 1442? If not, the chair would like to recognize Representative Johnson to close on her bill.
Thank you, Chairman Harrison. Welcome, Representative Morales. And again, Representative Schatzline, thank you again for your consideration of this bill. We would ask for the favorable passage to again correct what we passed last session to allow for the seizing of the asset of a vehicle when it is used as a criminal instrument in street racing. Thank you.
Great, thank you, Representative. If there is no objection, HB 1442 will be left pending. Is there any objection, members? Hearing none, the chair, the bill will be left pending, 1442. Thank you. And members, that concludes today's agenda. If there is any further business for the committee to address, I will ask that as a question. Is there any further business, members? No? All right. If not, the chair moves to adjourn. Any objection? Hearing none, the committee stands adjourned at 12:09 p.m., subject to the call of the chair.